And later, when they finished with the evaluation, they returned the documents, and then they were missing documents, which makes it irregularity. And at that same time, he also stated that one of the BEC supply chain members resigned from the BEC due to irregularities he experienced. And that is from Mr. Mpefu's report that he submitted to the Executive Adjudication Committee, with a request that this tender be cancelled and restarted.
Mr. Moloko Racheku in 14.1, is it the same person as Director Racheku in 10.1?
Correct. And then obviously the decision was made at the bid adjudication that this tender be cancelled and start afresh because of irregularities that was mentioned in it. However, one of the bidders, Lebele Lang Mashlatsi Trading Pty Ltd, they approached the High Court in Gauteng with a case number of 32325 of 2017. And Justice Fabricius on 24 May 2018 directed that this tender may not be cancelled, it must be re-evaluated afresh, and the same order of the Justice Fabricius also extended the validity of this procurement process by another 90 days. In compliance with this order, a second BEC committee was then appointed to evaluate the tender afresh. This 90-day period is that when a tender is advertised, it normally will have an initial 90-day period that it must be concluded within. So this period is obviously been passed, and that's why the judge then made the ruling that that period be extended to start the process afresh for evaluation only. And then the second BEC committee members which were then appointed was a Mr. Chris Tipe, who was the chairperson, and he was the divisional head of Treasury Department. Mr. Mtubeli Kolisa, he was the group head of Environment and Agriculture Management. Mrs. Verusha Morgan, who was the group head Property. Mr. Kwena Nkoko, group head Health. Mrs. Nosipu Slachwayo, the group head of City Strategies and Organizational Performance. And a Pamela Rakulele Ngabutle, who was the deputy director Demand in Supply Chain Management. This committee, after evaluation, it appears that they again resolved that the tender be cancelled due to irregularities during the bid evaluation process, still linked to the original missing tender documents, which were deemed to be highly irregular. And at that stage, the group of 22 companies that were originally proposed to be awarded the tender approached the court again. And then a Ladyship Justice Molopo Setosa issued a court ruling on 22 October 2021 that the tender be awarded to the 22 companies, and the city must enter into a service level agreement with this list of companies. And for that matter, it is listed the court ruling as RS25. And then based on that court ruling, the city drafted the SLAs, and the tender then officially commenced on 1 March 2022 with this list of 22 companies that was awarded in the ruling by the court.
Commissioner, would you please look at file 4. I want you to read the contents of Annexure RS25 into the record. So it will be, it's a smaller file. It's file 4 of 4, and then I refer you to page 945.
I confirm that that is the court order that was issued by Her Ladyship Justice Molopo Setosa.
Yes, can you just read at least the first paragraph on that page? So paragraph 1, it actually spills over to the second page.
Sorry, must I read the order into the record?
Yes, please.
By agreement between the parties, it is ordered that 1, the respondent's decision to cancel tender TMPD 02 2016-17 is substituted with the following decision. 1.1, tender TMPD 02 2016-17 is awarded to the applicant and such other bidders who 1.1.1 were recommended for the supply of physical guarding services to protect council property and personnel of the City of Tshwane for a period of 3 years at variable amounts as reflected in paragraph 20 of the report of the Bid Evaluation Committee at page 003-93 of the case lines record, and 1.12 are registered with the Private Security Industry Regulation Authority as at the date of this order. 2, the respondent is ordered to conclude service level agreements with the aforesaid bidders, which agreement shall detail the agreed services to be delivered, how such a service is measured in the provision thereof, and the response time required for such a service. The respondent is ordered to pay the applicant's cost, save that the cost of the day in respect of 21 October 21 will be taxed on the unopposed scale.
Thank you, Commissioner. Just to be clear, okay.
Before you move on. Morning, Commissioner.
Morning.
In that paragraph 19, the very last line where you say the council then started the tender on March 2022, paragraph 19 of your statement,
Yes, Commissioner.
when you say it started the tender, you mean implementation
Correct,
of
Commissioner.
that tender, not a new tender process.
No. It's because of the court order on 22 October, it took a while for the corporate and legal to design and create the service level agreements. And then the service level agreements and the contracts and everything was only completed in February 2022. And the tender then commenced 1 March 2022.
Okay, thank you.
So because the tender was a 2017, 2016, that year, I think, going into the next year, 16, 17, if it was delayed for what looks like 4 or 5 years, does it mean the previous service providers had their contracts extended on a month-to-month basis?
Before this tender?
Yes, what happened
Correct.
between 2017 and 2022 when this tender was restarted, as you say on paragraph 19?
Correct, Commissioner. There was a tender in place with a group of service providers. And when this tender process was initiated, it was obviously to replace that previous tender. And when the first court interdicts and rulings started, those tenders were extended on a month-to-month basis up to February 2022. So effectively at 28th of February 2022, those tenders then were completed, and on 1 March 22, this 2016-2017 tender actually commenced.
Commissioner, you say that the tender was eventually awarded after a second approach to the High Court to 22 companies that were originally proposed to be awarded the tender. I've been going through this back and forth. I don't see where it was proposed that the tender be awarded to the 22 companies.
Commissioner, in the BEC committee's minutes
Yes.
that they submitted to the BAC, the Bid Award Committee,
Yes.
in that report, there was a total evaluation of 22 companies.
Yes.
And they did the complete evaluation. And that 22 companies have been in the BEC the whole time. But when it was then submitted, the whole report about that 22 companies was submitted to the BAC with a recommendation that that whole process must be stopped and cancelled. So it was not awarded to the 22 through the city's actions. The whole way, even though they were evaluated, and there were 22 companies that was deemed to be by the BEC successful, that report continuously then stated, but there's missing documents, there's irregularities, and therefore when it got to the BAC took that in consideration and said, but there's missing documents, it's highly irregular and it should be cancelled. The then chairperson of the BAC was a previous CFO of the city, Umar Banda, and he signed off and said it must be cancelled due to irregularities. However, Judge Fabricius very narrowly in the first court order, and I'm not obviously saying I've got an ethical response, but I'm not saying the judge was wrong. The judge did the legal correct thing when he stated that the then legislation had a very narrow portion that you can cancel a tender with. And the words irregular or missing was not in that wording. So he ruled that you cannot use that to cancel the tender. That's why it must be start afresh. And obviously today with hindsight, when you hear the word irregular in my head, it should be cancelled immediately. We shouldn't proceed. And then in the second BEC, they took the same report, the same companies, and stated these were the most successful companies in the evaluation, but due to these missing documents, it is still an irregularity and we must be cancelled. And the chairperson again, Mr. Banda, again said, no, it must be cancelled because of this irregularity. And that's when the 22 companies, because the city, I don't know how it got out, but everyone leaked most probably the information, and then the 22 companies knew that they were deemed by the BEC to be successful, but they took then the decision to court to say, no, but we are successful, and that's when the court then made the ruling to say that those 22 companies we initially were must be awarded the tender.
Thank you for the clarification. I guess what confused me was the fact that it appears, both from what I read here and from what you say now, that there was never